Slide up.
Part 2 of the marijuana $300
There we go.
bill.
Okay, thank you. Chairman,
Mandatory
Mr. Chairman,
minimum.
committee, my name's Tony Oxon. I'm from Nampa, proud to live in Idaho. And one of the things I am proud about is we have a policy of no drugs here. There's no fentanyl, there's no cocaine,
Yeah.
and marijuana's not legal here either.
Yeah, this is
But we're not here to talk
Scott's
about the
buddy
legality of
and
marijuana at this time.
Oil's buddy.
We're here to talk about the penalty. And you've heard some people say that, you know, it's unfair for the $300 penalty for marijuana possession. And you've also heard people say that it was not a deterrent. You've also heard people say that, yes, it is a deterrent. In Oregon, they do know that in Idaho, there are penalties for this. I absolutely support HB 7 for establishing a minimum penalty for marijuana. And the information will get back to the people who use marijuana. And I truly believe it is a deterrent on here. And I'm proud to live here where we stand up for that.
Any questions? I'm just going to throw this out here, Mr. Oxon. So a stop sign violation or a speeding violation, that if you're going over 20 miles an hour, it's an enhanced penalty, it's fixed. Does that deter you from speeding?
Possibly. Most of the time, in my opinion, I was raised in a family where you say, I'm not telling you to not do the thing or do the crime, but be aware what the penalties are. You know, you have to be willing to accept the penalties for it. So that's the world I live in. So if that was the case, it probably would affect my driving too, if I knew that there were mandatory fines and what they were, yes.
Thank you. Monica Gray? When you're ready.
Thank you, Mr. Chairman, members of the committee. Thank you for having me today. My name is Monica Gray. I'm a Boise resident, District 18, and I'm a career public defense attorney. I'm in my 13th year of law practice. I've been a public defender for 10 and a half years, and I represent indigent people accused of crime. All of our clients must qualify for a certain financial poverty threshold. And the reality is that in our courtrooms, the majority of our clients are public defender clients. I'm a trial attorney. I try cases from low-level misdemeanors to capital qualified murder. I am currently the managing attorney of the ADA office of the Idaho State Public Defender. Our office represents many people accused of the crime at question today. Possession of marijuana less than 3 ounces, a misdemeanor. With all due respect, I'm here to express my support against the amendment to this statute today. And I agree with both the supporters and the naysayers of this bill that the question here today is not whether to recreationalize marijuana in the state of Idaho. The question is about the mandatory minimum $300 fine. Our concerns is that this bill will disparately impact our public defense clients. They make up the majority of accused persons for these crimes in a courtroom. This bill will unfairly affect those financially indigent who cannot afford to hire their own counsel, let alone easily pay a $300 fine. This includes students who are working to further their education, those on disability struggling with mental or physical health issues, and those simply struggling to make ends meet in today's economy and high cost of living. This means that people are largely charged with this on what we would call a street level crime. Typically, we see police stopping individuals and individuals being caught with marijuana on foot, in cars, in public. Certainly, these can be charged inside of an individual's private home under lawful circumstances, but it's not common. And what this means is that this crime is not often charged against those who can typically afford the $300 mandatory minimum. This current statute already allows a maximum of a $1,000 fine, as do almost all other, misdemeanor statutes. To give you an idea of a misdemeanor sentence, In addition to any potential fine, there's a court cost, which typically is an additional almost $200. For this charge, there's a mandatory minimum of 100 hours of community service, which our clients must pay for as well. There may be a substance use evaluation and treatment that also requires a cost or a fee to it. There's a cost of supervision for up to 2 years of supervision, monthly as well. Our concern is that a mandatory minimum fine not only will not be able to be paid for by our clients, but will lead to probation violations, incarceration from those violations, contempt proceedings, and their simple inability to adhere to their court-ordered rehabilitative sentence. And I can stand for any questions because my time is up.
Representative Heather Scott.
Thank you, Mr. Chairman. My question is, when you were talking about all these extra costs, so if someone, most people have all those extra costs in addition to this fine?
Mr. Chairman, Representative Scott, yes, a court cost may be waived by a judge, but it is almost always imposed. It is essentially a penalty assessment. It's known by a penalty assessment in other states' courts. It's the cost of doing business with the court. And then in order to comply with an individual's sentence for probation, treatment, evaluations, and the community service, there are fees and costs associated with all of those as well. So effectively, a $300 mandatory minimum fine ends up becoming a $500 fine at minimum if included with the court cost plus other fees.
Follow up?
Go ahead.
Thank you, Mr. Chairman. So if a judge is giving $2.50 fines, is it reasonable to say that it's possible he's reducing the fine in order to continue to get court cost? Do you understand my question?
Yes, Mr. Chairman, Representative Scott, I understand your question. I'm not aware of where there is the judge that gave a $2.50 fine. In my experience, it's not in my county. But yes, that would typically also come with court costs, mandatory community service under this statute and the fees that go along with that, potentially supervision costs, and mandatory costs associated with any treatment that may be ordered, which would have to be otherwise waived by a judge.
Representative Handy.
Yes, Chairman, Ms. Gray. Dan and I ran across a few things as a county commissioner where if a person can't pay the penalty or the fine, then they put them on misdemeanor probation until the fine is paid. And is that common, or is that just some crazy idea that they came up with in our county?
Mr. Chairman, Representative Handy, it is not uncommon that an individual may be placed on probation or in order to obtain a fine. In addition to all of the costs I've indicated, there's typically a restitution lab cost at least as well of a bare minimum of typically $97.50 that can't be waived. And in order to make sure that an individual is paid those, courts will often place individuals on probation so that they can monitor and so that there is some type of punishment suspended over their head were they not to pay those fines. And obviously the concern is that primarily our indigent defendant clients simply cannot afford any of those costs.
Representative Ehart.
Thank you, Mr. Chairman. And Ms. Gray, please forgive me. I walked in late. Would you please share with me your title again?
Yes, Mr. Chairman, Representative Ehart, I'm the managing attorney of the Ada County Office of the Idaho State Public Defender.
Okay, thank you. Fantastic. So, I feel I'm in a conundrum because I don't support the legalization of drugs. However, as I'm listening to you and I'm listening to others, we have another problem that I don't feel is adequately being addressed, but, our good representative Gannon had also essentially brought it up, and it's something I talk about, but I feel like there's a missing moral equivalency with other penalties. And if you could, maybe not necessarily drug related, but other penalties, do we have a problem of moral equivalency if we head down the path of this legislation?
Mr. Chairman, Representative Ehart, we do. And like my colleague, Mr. Riggins, argued, we are not asking for mandatory minimums across additional statutes here, but we do. In a most common everyday experience, what we see in a misdemeanor courtroom, DUIs, battery, assault, domestic violence, stalking, misdemeanor injury to child, disturbing the peace, a very wide range, driving without privileges, a very wide range of subjects. We do not see a mandatory minimum fine. Again, on almost all of these, there is a minimum of $0 to a maximum of $1,000 fine. So the judge does still have a discretion, for example, to choose to order a $300 fine. But each case is different and each individual circumstance is different, where they may be able to adjust this so that this individual can pay the fine. Possession of marijuana, misdemeanor less than 3 ounces, would be likely the only everyday common misdemeanor that we see in court that would hold a mandatory minimum fine. I know that Sheriff Getz, who testified earlier, indicated the second offense school bus stopping, and I believe that misdemeanor trespass can come with a mandatory minimum fine that may still be suspended, so there's a judicial discretion built into that as well. But this would largely stand as the sole misdemeanor.
And last follow-up. Thank you, Mr. Chairman and Ms. Grace. So on this imaginary list of moral equivalency and some of the things that you've laid out there with what you just shared, battery and all that, in the eyes of like your office, I'm assuming that you would not view the marijuana, this at the top of the list, but you're rather putting this potential misdemeanor more at the bottom of the list. I'm kind of fumbling through this. I'm just curious from your office where you'd rank it with what you typically see.
Mr. Chairman, Representative Ehart, you bring up a great point. And I would say, in general, our trial attorneys in the misdemeanor magistrate courtrooms where we have this range of the various statutes and crimes that you just indicated, possession of marijuana less than 3 ounces is not typically considered the most complex. It's not a violent crime. It is not a crime with a human victim to it. Typically we're seeing individuals with just very personal less than 1 ounce amounts on them. So no, it is not considered in there. I will caveat, because I am a lawyer and I need to caveat, of course, there may be a Fourth Amendment constitutional issue or something like that that creates this into a large and complex case. But on average, in an everyday courtroom, I think your assessment is correct.
Representative Erickson.
Thank you, Mr. Chairman. My question has been on my mind all day. So is there jurisdiction for the judge, or does he have the ability to or she to waive the fines in this case versus in the case where they're currently doing with the $1,000 threshold? If it's a $300 mandatory fine, do they have the ability to waive that and some of those other fees you mentioned in their when they're talking about a family that or a member that's committed the crime that may not have the funds to be able to do that? Is that part of their discretion or not?
Mr. Chairman, Representative Erickson, with a mandatory minimum fine, the judges would not have the discretion to waive that fine. They may have the ability to waive a court cost, although, as I indicated, the court cost is sort of the cost of doing business with the court. We have court personnel that are neither judges, public defenders, nor prosecutors that we contribute towards. And so I would not say that that is common and required a very low threshold. For the requirement for community service discharge of a minimum of 100 hours, I'm not aware that, at least by the judge, that can regularly be waived. And the costs of evaluations, treatment, those would typically be sent out through private providers. Those private providers may have a sliding scale, but a judge cannot, for example, order an individual to go to a 3-month outpatient substance use program and order that private provider to waive their fee. So our clients are typically still going to be on the hook for those additional fines and costs.
One follow-up.
Hello?
Do they have access to some funds from the court that supports those families in those cases where they pay for it rather than the family?
Mr. Chairman, Representative Erickson, it depends. Depending on what the charge is, you may have access to some funds. Probationers, for example, may have access to funds that non-probationers do not have access to. Many of our clients seek funding through BPA funding, Medicaid, things along those lines, or rely on providers that have sliding scales based on indigency, but it is not automated or ordered by the court that their treatment be at the cost of the court, and I would say that's rarely the case.
Okay, I have a question, and I do thank you for your service as a public defender and given your experience. Thank you. But I would ask, in the last year, if you can tell me what percentage of clients were not recreational users of marijuana that were prosecuted and you had to defend in your office?
Thank you, Mr. Chairman. And do you mean recreational versus medical use?
Yeah, yes, if you can clarify that.
Thank you, Mr. Chairman. The short answer is I don't have that specific information. That may potentially require us to reveal client confidences and privileged information. I can let the court know that that's not delineated under the law, and our job in the courtroom is to follow the statute, so that's not typically a question that comes into play.
Do you have the experience and opinion, though, of most of your clients if they're recreational users of marijuana in these small amounts?
Thank you, Mr. Chairman. To be honest, I do not have a specific opinion one way or the other. I've had plenty of clients. I know we've heard from veterans who receive VA benefits. I've had plenty of clients that are charged with this and are former veterans or things along those lines or have some type of terminal illness. And I've certainly had plenty of clients that I simply just don't have that information on.
And then a follow-up question. I had the numbers last year and I've forgotten. What's the range for a cost of 1 ounce of marijuana? There's, of course, different gradations. I know the really expensive stuff and the lower stuff. Do you know what those numbers approximately are?
Mr. Chairman, I do not know that exactly. I can say that, again, without revealing privileged information, which is my number one duty here today, this committee, I think, can understand that we are close to states where marijuana has been recreationalized, and we've found that that cost has gone significantly down. Certainly, the personal possession amount, for example, one joint that a client may have in a car when they're stopped, is not going to reach anywhere near the $300 mandatory minimum.
Rather vague. All right.
Doesn't align with
Any
you,
other
does it,
questions?
Mr. Skaggs?
All right. Thank you for your time and testimony.
Uh-huh.
Representative Hill.
I just had a data point for you there, Mr. Chairman.
You need to
that,
work,
they sent to me.
eh,
It's
Scott? You
$100
need
to
to have all these
$150
people
per
in
ounce in
jail,
Ontario
keep
to
you
buy
busy?
marijuana.
Thank you.
Not that I know that, someone told me.
Thank you, Mr. Chairman. Thank you, members of the committee.
There's some, Representative Hill, there's some men in the room that can follow up with you about that. Brian Bauman. When you're ready.
Mr. Chairman, representatives, thank you for the opportunity. My name is Brian Bauman. I'm in District 21. I live in Meridian, Idaho. I can respect and empathize with every single person who has given testimony today. We've heard some powerful testimony. I'm here simply on economic grounds. I'm an insurance agent. I work for an agency that represents hundreds of construction companies across the state of Idaho. We are a part of the Association of General Contractors. We're also a part of the American Subcontractor Association. All of these groups and all these companies face one major issue today: a lack of employees ready for the workforce. We do not have enough qualified men to backfill labor-intensive construction jobs. Simply put, there's not enough people to work. My concern is if we do not adequately deter marijuana usage, it sends a message to young people that it's not a big deal. Word gets around, and these fines do matter. We
Yeah.
need 10,000 new people to enter the construction workforce in the next decade.
Yeah, and you want to
If
deport
we
every
don't,
one of
we
the
will
ones
see
that
costs
are willing to come
continue
up
to
here
go
from,
up. It's already well over
From south of the
$100 to have
border,
a
huh?
plumber come to your house or a handyman,
come on.
and it's only going to keep going up. This acutely impacts those on a fixed income. It's my belief that the only thing more detrimental than having tens of thousands of young people enter our workforce who have a TikTok addiction glued to their right hand is to have thousands of young people entering the workforce with a TikTok addiction on one hand and a joint in the other. So I would ask you,
You know,
to be
there's
consistent
a lot
and
of
fair
people
with the
and a lot of
marijuana
youngsters
fines
that
you
don't
give out,
take
but
that
set the
stuff.
tone
I never smoked
that
it.
Idaho needs
Knowingly.
employees, and marijuana is not an effective way to motivate a workforce. Thank you.
Oh, that's a false narrative altogether.
Representative Gannon.
Thank you, Mr. Chairman. And sir, I'm just thinking that from my experience and all the kids that I deal with, we got 7 between us. Isn't alcohol a more serious problem for construction in the construction industry?
Answer if you know.
Mr. Chairman, in my experience, we have numerous things that are impacting the construction industry. Alcohol, drug use, social isolation. Yes, those are all major issues. So it's a multifaceted issue.
Hey, no questions. Thank you, Mr. Baumann. Rex Ingram.
That guy. Is he on the SCOG payroll or?
Good afternoon, Mr. Chairman, committee. I had a speech prepared. I'm the Chief of Police in Caldwell, Idaho, and I'm also the President of the Idaho Chiefs of Police Association, and I stand before you as in that role today. I'm in a unique position as I'm from Los Angeles, California. I came here in 2020 and escaped the savagery of California and the decriminalization of
Yeah,
every
that's why there's
law known to
49
mankind, especially
million
during
people in
2020 when we
California.
had zero bail, Prop 36, and
It's
all
not a
sorts
bad
of
place,
other
unfortunately,
lawlessness
now
happening on
that
the streets,
a
which
lot
we
of
just
people are
saw
really
firsthand
suffering.
last week during the devastating wildfires that plagued Los Angeles and the mass looting and the things that happened down there. So I'm here more just to answer any questions that you have. We, as the Idaho Chiefs of Police Association,
you
support
bet.
this bill.
Yeah.
We've heard a lot of really compelling testimony from veterans, from defense attorneys, and
How did you get
I
elected
wholeheartedly
anyway? Or
support
you
that and
just took the
encourage that.
job?
I
Okay.
think that we
You
have an
applied for the
obligation as
job in
Americans
Caldwell,
to
got the job,
provide
huh?
both sides of the picture here. But I want to just touch on a couple things. You know, specifically with PTSD and veterans, I've worked around thousands of veterans in my career in the Los Angeles Police Department.
Thousands,
and
eh?
Not one veteran that I've ever served with or worked with was addicted to or used marijuana to cope with their PTSD. I will be the first one to say it. I have PTSI, and I'm currently being treated for that by clinicians and by other means, not drugs. One of the reasons why my family and I moved here in 2020 from Los Angeles was specifically because in Idaho, you guys make laws that uphold the rule of law, and law enforcement is able to have the opportunity to actually use the laws in their discretion to enforce those things. And so some of the testimony that we've already heard specifically from the defense attorneys is that they only see people that are their clients that come through their courtrooms. In law enforcement, we work 24 hours a day, and we see people that might have less than 3 ounces. We might see people that might have more than 3 ounces. And those officers have, based on case-by-case experiences, and they have the decision-making ability to enforce the law based on what the law says. Now, it's up to a judge to impose that mandatory minimum, but I can tell you that by having a mandatory minimum for marijuana, which there's been a lot of testimony already, that sets the tone. And yes, it is true. I've heard on wiretaps folks in other states like Oregon that have specifically said they will not come to Idaho to deal narcotics because of the mandatory minimums. And so the last thing is,
What
there's
about
been a lot
the
of
people in
testimony
Idaho,
regarding,
sir?
Folks that
serve
can't
the
afford the
people in Idaho,
$300.
or are
I'm
you
sorry, but
serving
if
yourself?
people are choosing to use narcotics that are already illegal substances, then they can,
There's
in
over
my opinion, in
600,000
our association's opinion, pay
youngsters
for that fine.
arrested
And with that, I
every
stand for
year.
any questions.
In jail for marijuana.
Thank you, Chief.
Fills the jails. Plus, they don't get to
Honka.
vote.
Yes,
For the
Chief.
felony.
Appreciate you coming down and testifying. So real quick, let's say you pull over individual and it's their first offense. So would it be the officer's discretion, and it's under 3 ounces, I don't know, maybe an ounce, and they find drug paraphernalia. So to give that individual a break, do you think the officer may just cite him for drug paraphernalia and not the marijuana? And then second on, let's say 3 months later, they get pulled over again, same situation, but they find, then that officer would have that discretion, well, you know, I have to send a message home to you. Now I'm going to cite you for the marijuana.
Chairman Skog, Representative Pahanka. Yeah, I mean, it depends on the case by case, you know, and the totality of the circumstances. And I hate to say that, but that's really what it comes down to. You know, location, time of day, who the person's with. Is it for medical purposes? What's their attitude? What's their demeanor like? How much is it? You know, and is it associated with a crime? Are they in the process of committing a crime? Are they leaving a crime scene? You know, so there's all types of factors that go into it, not just, you know, they're in possession, the mere possession of it. And we had this discussion last year as well with, you know, with the fentanyl stuff. And so really it comes down to everything at the time what the officers know based on reasonable suspicion and probable cause.
Representative Ehart.
Thank you, Mr. Chairman, and thank you, Police Chief Ingram.
Yes, ma'am.
Yes, okay, sorry. 2 questions. The first one I hadn't heard before. What is PTSI? Chairman
Skog and Representative Ehart, it's post-traumatic stress injury. You know, there's a shift in the psychological world of, instead of treating it as a disorder, because disorder has a bad connotation, we are now treating it as an injury, just like a back injury, so we can get people back to work.
Okay, no, thank you. I wasn't sure. And then, second question, Mr. Chairman. So you stated, and I'm just double checking on if that's what you meant, that it's up to a judge to impose mandatory minimum. It's my understanding that the judge has no ability to do anything but impose a mandatory minimum. Are we understanding something different, or was that just meaning that the judge would just do what the judge has to do?
Chairman Skog, Representative Ehart. Yes, thank you for clarifying that. And I was speaking fast to get through the time, but essentially, there was a lot of testimony earlier, specifically about on the left side of the room here, about different misdemeanors having mandatory minimums, not having mandatory minimums. And in my experience, all the ones that we were talking about, stalking, DUI, battery, ag battery, those generally have victims associated. So there's going to be jail time should the judge and the jury find that. We're not talking about monetary fines. And so with this specific one, just like other narcotics that are also illegal in the state of Idaho, we want to impose a mandatory minimum as a deterrent, which will give no judicial discretion for that judge in that specific case. Because in our opinion, if someone goes through the entire system to get to that point where a judge has to actually impose a mandatory minimum, then they've done a lot of work to get there, because the discretion and all the things that come into, you know, filing a case and going through that whole judicial process, it's a long process. They don't just show up in a courtroom and see a judge, you know, after a traffic stop.
Follow up?
Go ahead.
Mr. Chairman, and Police Chief, do you think with that which you just barely described, and I truly, again, I'm not in favor of drugs. I'm not. But I also want to uphold the law. So do you think we skip, or we maybe or abuse constitutionally the right to a free trial, which includes a judge, if we basically impose mandatory minimums?
Chairman Skog?
Through if you can.
Right, only if you can.
Ma'am, no, I don't. I don't think we do that. I think we enforce the law based on the Constitution, and we use the law to investigate crimes, and usually marijuana is indicative of something else at hand. And so it's up to the officers at scene to determine what those crimes are, and if there are none, then they can use that discretion to, you know, facilitate something else for that person.
Then last follow-up, truly. Mr. Chairman, Police Chief, then essentially we don't need the judge.
I'm sorry, I couldn't hear, ma'am.
Then essentially I hear you saying that we don't need the judge.
Chairman Skog, Representative, yes, we do need the judge.
Okay.
Any questions? No further questions. Thank you, Chief. Lieutenant Kimball, I see you there. I think you told me you were going to testify, but I don't have your name on the list. Was it your intent to testify today?
Yes, sir.
Okay, go ahead and come forward. That's it. It doesn't come up on my computer. I have to look at my watch for your 3 minutes, so.
I apologize for that. I signed up online before I left the office, so I thought I had it covered. My name is Jason Kimball. I'm a lieutenant with the Nampa Police Department.
Oh, yeah, Nampa.
I'm here representing Nampa Police Department today.
Scott's hometown.
My position with the Nampa Police Department is I oversee our investigation unit, which I have 4 separate units within the preview that I see. One of them is our narcotics unit.
Brothers?
The other one is our property crimes, then a special victims unit, and our violent crime unit. So I'm here with that type of background to talk to you about this bill. We're supportive of this bill. I'd like to see it passed because of the mandatory minimum. What we've seen in the past
in jail,
with,
right there?
marijuana specifically is very light sentencings or little to no sentencing. What this gives us the ability to do is when we charge somebody, when we arrest somebody with possession of marijuana, we know what the outcome is going to be. Before, it could be
I was in Germany
a year in jail, $1,000 fine.
October.
This limits it to $300.
And they legalized
We're supportive of
marijuana
that.
in Germany.
One of the things I brought here to talk about
to a
was how
family there, and they said that they have a plant growing in their apartment
in our
for
community
their use.
in a negative way, how it impacts people's mental health, cognitive function, all the way down to their ability to drive. And we frequently see
this is all financial
DUIs
based on law enforcement
that are people that are under the influence of marijuana. That has gone up significantly since we've seen our border states legalize
Oregon,
marijuana.
Washington.
So we support this law because of the ability to enforce it more effectively and detour the future use of it
Utah,
by our youth.
That's a little different. All around Idaho.
Any questions?
And
questions?
Governor Little said, yeah, if you wanted someone to legalize or decriminalize marijuana, you let somebody else.
It
this
sounds
is
to
baloney.
me
This is
it is a deterrent, the mandatory minimum. Now, there's been some question, and I have my own opinion on whether marijuana is a gateway drug. In your experience, I assume you've dealt with the community for periods of time. Do you see, in your experience, marijuana being a gateway drug in your in the activity, if you will, through the years?
Mr. Chairman, Representative Hustler, the answer is yes. It is a gateway drug, just like we would see with anything at the end of it when somebody's overdosed from fentanyl. They didn't start with fentanyl. They didn't start with that drug that killed them. They started with marijuana, either at a young age, a juvenile age, or at a young age, and then they progressed to a harder drug, whether it be fentanyl or methamphetamine, heroin, cocaine, something like that. So yes.
Thank you. Follow up, if I may. So it's logical to think that this mandatory minimum actually is a deterrent, which means it could deter someone from moving from a soft drug onto a harder drug, soft drug, from marijuana onto a more advanced drug. Is that fair to say?
It's some children, but they're saying every time.
Yes, the answer to that is yes. It would. The goal behind this is to deter our future people from using this drug in a recreational, way, or any other way that the habitual user to continue using that. What we see frequently are people who start off young. They see there's not a deterrent from our legal system, so they think it's acceptable and continue on, and then take that next step. It's much like that line in the sand. Once you cross it, it becomes much easier to take that next step, and the next step, and the next step.
Seeing no further questions, thank you, Lieutenant.
Thank you.
One more person to testify on the list, Thad Butterworth.
Mr. Chairman, members of the committee, my name is Thad Butterworth, and I am here today representing the Ada County Republican Party, and I do reside in Meridian, by the way. I was part of the resolutions committee that helped pass the resolution that was addressed earlier. And one of the things that we found really important, and I'll give some of my own personal experience with this and why I was debating so heavily for the resolution that we passed. As a business owner, I was actually one of those working in one of those construction industries that was previously mentioned. We were dealing with glass, which is a very dangerous substance. If you didn't know, it can break in all kinds of unusual ways. And one of my constant issues I had was employees that would go over the border to Ontario and or other places west of us and purchase those drugs and then come back and they would be using those. It was a lot harder to catch than alcohol. There were employees I had to fire because of alcohol usage, but I could catch that very fast. It was a little bit harder to catch marijuana usage. I have actually interviewed people who came from some of the states like Colorado where drugs were totally legalized, and they had left not only the state, but it really took a lot of work to even convince them to come and work in this industry because they were worried that something like that would happen here. They left the industry because the danger of drug usage when you're dealing with a dangerous element like that. So that's part of the reason I was really for that resolution that we passed. And also, you know, if we don't have a mandatory minimum and with some of the sentencing issues that I've heard, we're basically in a de facto way legalizing marijuana if we don't have a strong deterrence. In my situation, if there had been a very strong deterrent, I had probably employees who would have not indulged because at least, you know, they wouldn't have been able to purchase marijuana for the next couple of weeks if they got caught with it. So there is a real strong reason and a very strong motive behind putting a mandatory minimum sentence in because we really need to address this now, both for industry, for the sake of our youth, and for the sake of our state. We do not want to go down the road that Oregon and Washington and Colorado have gone down. And with that, I will stand for questions.
What's your, no questions, right?
Representative Ehart.
Oh, here. Oh,
Thank you, Mr. Chairman. Mr. Bretterworth, I'm not sure. I've actually got pinged by some people that maybe didn't quite see the resolution as being portrayed, that wasn't necessarily the agreement, but that's neither here nor there. So with your testimony and the question that I had asked, previously to the good gentleman, law enforcement, what role, being a constitutional republic, you being the chairman of Ada County, what role does the judiciary have when a person is brought up before the courts, and does that violate their rights if they're not allowed to have sentencing from a judge?
Do you understand the question, Mr. Butterworth?
What was that?
Do you understand the question, Mr. Butterworth?
Yes, I do understand the question. Mr. Chairman, Representative Ehart, I do not see that as a constitutional violation because of the fact that you are still going to a judge. They are still going to determine what the disciplinary action is, but they do have there's just a minimum set. It's no different than having a maximum fine. It's just setting some limitations to where you can't have a situation where a judge, for whatever reasons, decides to basically de facto legalize a crime because they're not going to put a defective or an effective deterrent on it. Does that answer your question?
Mr. Chairman.
Go ahead.
Having been in here, I think I know the answer that you're trying to say, but no, the judge doesn't have discretion in that. So that was really my question. It's a mandatory, meaning the judge has no discretion. It's mandatory.
Representative Ehart, you're being argumentative with the witness. You are being argumentative with the witness. Save that type of thing for our discussion.
Sorry, my apologies there, Mr. Chairman, and was sorry, Mr. Thadworth was trying to redirect so that you might have that opportunity to answer again, but no worries, we're fine.
Okay. All right. Any further questions? Representative Carlson.
Thank you, Mr. Chair. Thanks, Mr. Butterworth, for bringing this before. Since you were involved in the resolution that brought this to this committee, I've heard quite a bit of discussion today about kind of wavering judiciary discretion. I think you just mentioned that they're moving towards legalization based on discretion. We've heard quite a bit about some judge somewhere that likes a $2.50 fee. Can you give us any data on how that fee has changed? What's the kind of standard issue by a judge in the state of Idaho? How has that changed over time? How does that compare to the $300 that the committee is considering today? Thank you.
Mr. Chairman, Representative Carlson, I do not actually have any data on how that's changed over time. That's not something that we necessarily brought into the debate at all. I do believe that it's been fairly
widely varied across the state from what I've seen and what I've heard about. Like I said, I don't have any real strong hard data on that.
No facts, I heard, just like Fox News.
Representative Gannon.
Thank you, Mr. Chairman and Mr. Butterworth. And maybe for anybody who's mentioned it, who is the judge that did the $2.50 fine? Can I get a name and the actual case?
Mr. Chairman, Mr. Gannon, I do not have that information.
Yeah, I just heard it, right? Yeah, just say you heard it. No facts. Just false narrative.
Thank you.
Have a nice
Further
day.
questions? That concludes our testimony today. Committee, Representative Redmond, go ahead and come back. You may rebut or give any comments you'd like to on your bill.
What you wrote.
Thank you, Mr. Chairman and committee. I also want to thank the public for being here and testifying. It's part of our process, and I really do appreciate all the testimony. Going into this hearing, I didn't anticipate it being as emotional and as contested as it was. But that being said, I really do want to focus back on what the bill is. And what it is it sets a minimum fine to act as a deterrent for an illegal drug that we have in our state. We heard some extremely compelling arguments in testimony today that dealt with the use of medicinal marijuana. And honestly, maybe that is a conversation that this body should have, whether we want to look at medicinal marijuana for some folks that are dealing with some extremely tough issues. But that's not what this bill does. This bill simply sets a minimum fine. And with that, Mr. Chairman, I would ask this committee send House Bill 7 to the floor with a due pass recommendation. Thank you.
Yeah,
There may be
like the
questions. Any
420
questions of the presenter?
of SCOG last year.
Thank you. House Bill 7 is probably before the committee for discussion and or motion.
Well, let's see, huh?
Representative Gannon.
Thank you, Mr. Chairman. I did locate the $2.50 in the materials that were provided. Can I read what that full sentence was?
Certainly, we all have it with us. Go ahead.
Okay, it's in the Washington County, and it says a person, Toby, I won't give the last name, possession of marijuana, fined $2.50, sentenced to 180 days in jail, 178 days suspended, placed on 12 months probation, 100 hours of community service, plus $454.50 of court costs. And the next person was very similar, except the court costs is the same, except the court costs are $197.50 instead of the $454.50 that this Toby had. So there's considerably more to this sentencing than just $2.50.
It kind of blows you away on hearsay, right? Way to go.
Representative Hill.
Representative
Mr. Chairman,
Gannon.
for a motion.
Go ahead.
Mr. Chairman, I move to send House Bill 7 to the floor with a due pass
Oh,
recommendation.
yeah, you would.
Is there further discussion?
Doesn't require a second.
Chairman Skog, just for a substitute motion, then if I can speak to it.
Certainly.
I move that we, a substitute motion is, I move that we hold this House bill in committee. And I've struggled with this through this whole discussion, and I've flopped back and forth because I am very against drugs, and I have a hard stance on that. I've never used them myself, and I think they...
Me neither, Dan.
destroy the fabric of a family and everything. But what concerns me about this bill is that it takes away the discretion of our judges to decide the merits of each case and to dole out the proper thing for each case.
Yep.
And I feel like the judges do a very good job doing that. At least the ones in my district do. I've sat in on a few drug courts, and they are always emotionally challenging and hurtful. And so it's a bad thing to have drugs in society when they're misused. But I do believe the judges do a great job in deciding the best punishment, if that's what you want to call it, for each circumstance, or the best way to see them support the defendant that is having a problem. And I would hate to take that away from our judges. Thank you, Chairman.
Representative Hawkins.
Thank you, Mr. Chairman. And I would speak against the motion. And I've been taking notes as we've been going forward. And I will admit and ask forgiveness now to the chairman for violating his rule and turning on my phone to look up the cost of marijuana in Idaho, because I think we're naive if we think that it only comes from the Oregon border. The average cost of 1 ounce of marijuana in Idaho is $244 now. So I heard a lot of testimony. I can't even wrap my mind around our veterans and what they're suffering from. And those are separate issues, I think, than what we're talking about here.
From last year.
The other thing I heard a lot about was, what about the people who can't afford it? Well, why are they being able to afford $240 an ounce marijuana?
Millions and millions. Was that
and are we trying to make it easy for them to repurchase? I heard several times, well, if they have to pay a $300 fine, they won't be able to afford treatment. But then we heard testimony that treatment is usually supplied by the court or through Medicaid. So if they're not fined $300, my guess would be they're going to go buy another ounce of marijuana, and we're continuing the vicious cycle of drug abuse. The issue of taking away judicial review of these things, we're not arguing in here that, well, they can only go up to $1,000. We've limited the judges. Nobody's arguing that.
You're spinning the
all we've done is set a floor.
You know, everybody's got an opinion
for a violation of Idaho law. Are we going to be people that uphold the law, or aren't we?
Of course,
$300. They can still do the sentencing. They can still take that fine from $300 to $400 up to $1,000. We haven't done anything but say this is the minimum.
Is what is paid.
Because at one time there was a question asked, do we need the judges? Well, of course we do.
1,400 candidates.
Because everything in between that is filled in, including jail up to a year, which we just heard of a case where, I guess, where the fine was imposed low, but there was a jail sentence suspended, and then they were giving community service as well as probation if you have a suspended sentence.
I like Dan Gardner.
I just don't see this as
I'm against drugs. We've had it in our family,
some people are looking at it.
We
have a huge problem with drugs in the United States in general.
Power to the.
And I heard testimony earlier about what Oregon a couple years ago. They just said, "Well, let's do them all."
You think you're going to do all you're going to do
now? They have backed up on all of that. They've destroyed their cities because of drug abuse. And
building contractors
I just don't think that this is that much of an intrusion.
Police will have plenty of
I
jobs.
would be voting for the
guys who return from
motion and sticking
the
with
National Guard members will have opportunities for work.
Rubel.
Thank you, Mr. Chairman. Just to speak in favor of this substitute motion, and I guess by way of disclosure, I have known and been working with Sergeant Kitzhaber for years on this issue, and some of the similar injured and disabled and struggling veterans. Their stories are incredibly real, and this really is the only thing that will help them. And, I know this is not a bill about legalizing their help, but it is a bill about furthering their punishment, which I don't think is a move in the right direction. It says, I don't want to get out ahead of my skis on this, but Sergeant Kitzhaber contracted his cancer in the service of our nation. He was transporting toxic materials in the service of our military, and that is how he developed this incurable cancer, which has tormented him for years. And this is literally the only thing that will give him relief without causing a whole host of other medical problems. And there are other veterans and those struggling for whom this is the only answer. That's a discussion for another day. But today's discussion is about subjecting him and people like him to a mandatory $300 penalty and stripping away any ability for a judge to look at him and say, you know what, you're not the average pothead. You're maybe not the guy these laws were intended to punish. And for you, maybe a fine isn't appropriate. We're stripping that away because that's literally the only way this is going to come into effect, is where a judge who has heard all the testimony, seen all the facts, and decided, you know what, in this case, I don't think a fine is appropriate. That's when the rubber hits the road on this bill, is when a judge has looked at it and said, I don't think in this case it's appropriate. And the legislature's coming in and saying, oh yeah, you better fine that guy $300. I don't care if he has cancer. I don't care if he's a tortured veteran. You better fine him. I am really not comfortable with the legislature going to that point. And trust me, we have lots of deterrence. We have lots of punishment without this bill. 39 states have legalized some form of medical marijuana. We have not. We are already in the upper echelons of punishment. We already have mandatory minimum sentences for prison time. We have a lot of punishment already. We don't need to pile on extra to worry about deterrence here. But I do think a fundamental precept of the law is proportionality. And I was struck by Representative Ehart's statement on moral equivalency. I get that we don't want to be a place where there are drugs, but, is using drugs bad? Sure. Is it worse than strangulation? Is it worse than domestic battery? Is it worse than DUI or stalking or any of these? Absolutely not. I think you'd have a really hard time making a case to anybody on the street that we should have a tougher penalty for smoking a joint in your own backyard than you should have for attempted strangulation or DUI. But that's what this bill would accomplish today. It would send that message that this is a more serious offense with a more serious required minimal penalty than attempting to strangle somebody. Again, definitely not a statement I'm comfortable making. So for all of these reasons, I think that, we should have many more discussions about other issues and about whether we can do something to help folks like Sergeant Kitzhaber. But I think we should not be making their lives more difficult in ways that don't further deterrence and that I think really trample on the notion of moral equivalency and proportionality in the law.
Representative Hostetler.
I'd like to, thank you, Mr. Chairman. I'd like to argue against the most recent motion as well and kind of piggyback off of what Representative Hawkins said. And honestly, we did hear that there are some larger repercussions for some of those infractions. There are victims involved. There's jail times. So I understand what you're saying. I think we've heard that that's not necessarily the case. If we impose that minimum fine, that marijuana possession is going to be seen as a greater infraction than some of those. But I do want to look at the greater issue. And I also don't want to discount a lot of the testimony we heard today, because there are some real issues with some greater problems, and it's a small portion of society. And once again, does not discount the validity and the emotional impact and really the long-term realities that we have to deal with some people, whether it's mental health or some other programs, whatever it is. Those are some side issues. But I do want to talk about the greater issue here, which is what a few of our officers testified to, that they see this as a deterrent. And they also see marijuana and in their experience as a gateway drug to worse drugs, and drugs really that lead and open the door to greater crimes, whether it's murder or theft or battery or things that actually are greater infringements on our society, economically, morally. So I really think that we have to look at this as a long-term issue and stand firm. We are just sticking to the four corners of the bill, as my colleague said, and imposing a minimum fine for a drug that is illegal that we do not want here. We do not want to open that door. And I mean, it's safe to say that crime does not pay. And in fact, you should be charged if you're going to commit a crime. And I'll leave it at that. Thank you.
That's set up. So Scott got you back it over.
Thank you, Mr. Chairman. I'm going to support the substitute motion, and I agree. If we start down this road of mandatory minimums, we're going to have to come back and address a lot more serious crimes of strangulation or DUI or some of these other issues. Obviously, we don't want people doing drugs in our state, but for those of us who have been around this committee for a long time, you see what comes in, and pretty soon now we're going to start setting mandatory minimums for every single thing in this state.
Yeah,
and if we
like
don't trust our judges, what are we doing? I mean, they just came to us today wanting more money, but next to $200,000 of that. So we'll just defund them, and then we'll just make all the decisions here. I definitely think these judges have discretion on what they're doing. I'm not saying I think they should have more money at this point, but they know all the details. They know what's going on, and we don't. And it's really nice and easy to just set up a cookie cutter sentence and a cookie cutter consequences, but people don't fit into cookie cutter situations. I won't even get into public schools and how we set those up as cookie cutters, but we don't want to set up our courts as cookie cutter courts. And that's where I think we really need to think twice before we just start setting mandatory minimums for every single thing that comes by. And there's a lot of crimes. I'm not saying anyone's worse or better than another, but strangulation, that sounds pretty bad. DUI, it's pretty bad when you're hurting other people. So something to think about.
Bravo, I agree with you for once. I agree with you.
Representative Gannon.
Rarely.
Thank you, Mr. Chairman. And I just wanted to clarify and be clear on what that apparently a lot of this movement towards this was based on this $2.50 fine. And in our packet from the Weezer Signal American, March 28th, 2024, yes, this particular judge gives a $2.50 fine, but this marijuana, for possessing marijuana, this individual had to serve 2 days in jail, 12 months probation, 100 hours of community service, and $454 in court costs. Now that is punishment. And so I don't think, and I think it raises the question as to whether we should be considering any increase in fine based upon the way that this judge chooses to implement punishment. Very, very serious punishment for possession of marijuana.
Bravo.
Thank you, Mr. Chairman. Yeah, one more thing. I was all ready to testify against doing something for a bad actor and thinking this judge was a bad actor. And after you read that, I do agree. He obviously knew the situation, and we didn't. And when you just look, that's what we're doing. We're looking from the outside, and we're making a decision, thinking it's going to be good for everyone, and we do not know those situations. And so that's
lots of false narratives, aren't they? Lots of
probably
BS.
wasn't a bad actor.
Lots of BS.
Representative Ehart.
Thank you, Mr. Chairman. A couple of things, as I want to clarify what the GOP actually said. The resolution with the GOP actually had to do with kids 18 and under and discouraging them from using marijuana. So just for clarification, because I think that lends a completely different thought process to it. Then, as you know, we come in here and we struggle. Those of you who are new, we struggle with the hard issues. We really do, as much as anybody out there. And what I would like to see is what Senator Groh did, 3-4 years ago, this is me, where we tried, and I worked very hard to get it in our Constitution so that Idaho would never be a state that would legalize marijuana. And I'm sorry for those of you who want it. I'm not in favor of medical marijuana. I'm not in favor of legalizing marijuana at all. I'd like to see that come back constitutionally. As far as the things in here, what I struggle with,
Idaho doesn't have a moat of
and I
alligators
continually
around
struggle
it,
with
man.
it and have for the last 7-8 years, however long I've been in here, and it is
And you're from
the
Idaho
mandatory
Falls.
minimum.
You work at a gym.
It is, in my opinion, taking discretion away from the judges.
And you-
As I've
you
said on
admitted
the
that
floor,
Title
and I've
IX
said it in
helped you
here, I have
get
had
into
long
women's athletics.
talks with what are considered in my area in Southeast Idaho, long talks with good judges. And without exception, they don't like this. And I have judges who also have, drug court. So again, I am not in favor of marijuana. And those of you who would like to see it medically legalized, you will not find a friend in me. But I do struggle with this in my idea of constitutionality. And so at least today with where we are, maybe I could go for a lower, I mean, I know it sounds like maybe I could go for lower mandatory minimum, but the moral equivalency, I don't see. Maybe I can, a year ago, I wrapped my head around some stuff, but at this point, I can't wrap my head around it. I'm sorry, so thank you. I'll support the substitute motion.
Oh, good on you. Good on you. Well,
Representative Schertz.
Thank you, Mr. Chairman. I'd like to speak against the substitute motion.
Okay.
Judges do have discretion, abundant discretion,
Okay,
clearly, and they would keep a lot of their discretion within this bill. You would end up with what would happen would be a range, a bottom of $300, a top of $1,000. But we
Schertz,
also
he's a
have
new
discretion
guy.
as a legislative body,
Okay.
right? And with that
Does Scott help
discretion, we
you?
have the ability to
Or
say
did,
that we do not want this state to be a drug state.
Uh-huh.
Now, let me tell you one thing. I live, my district is District 9, which is Washington, Payette, and Canyon County. We are the border between the drug shops in Ontario and you all down here in the Lower Valley. And if you go to Ontario, a place where I went often when I grew up, it is a completely different situation, completely different place than it is today, unfortunately, because drugs have now been legalized.
Oh,
So any ability that we can do to send that message that this is not a drug state, that we will not end up being a drug state, we need to be in support of. This bill does that, and it creates the
Have you
ability
ever
for us
been
to
out
say,
of the
hey,
state
if
of
you're
Idaho,
going to
sir?
spend whatever, $240 an ounce to buy marijuana, you certainly can pay the
And it's
$300
not
fine
$240
on the back
an ounce,
end.
I don't think.
You're going to have there's going to be some
And
cost
some
adjustment.
people
if
grow
you're going to
their
make that
own like they
choice,
do in
there
Germany.
has to be some
They have a pot in their-
penalty, or these laws mean nothing.
On their patio.
With that,
in your
I
apartment.
respectfully urge you to vote against the substitute motion and support the original bill. Thank you, Mr. Chairman.
Schertz, okay,
We're
Schertz.
done. Probably for the committee is a substitute motion to hold House Bill 7 in committee. We'll do a roll call vote.
Let's see if you got your ducks lined up, Skog.
Please turn your mics on when you vote so that we have the recorded record. Nancy has to listen to that later on, and she may hear you here, but it's the recorded record she listens to afterwards.
Here it goes.
So again, this is the substitute motion, which would table House Bill 7. Hold.
Representative Scott,
Yes.
Representative Ehart,
Yes.
Representative Erickson,
No.
Representative Garner,
Yes.
Representative Handy,
No.
Representative Hawkins,
No.
Representative Hill,
No.
Representative Hostetler,
No.
Representative Pohanka,
No.
Representative Schertz,
No.
Representative Gannon,
Yes.
Representative Carlson,
Yes.
Representative Rubel,
Yes.
Representative Skog.
No.
Ooh, here it comes.
Motion fails 6-8. Now we're on to the original motion to send House Bill 7 to the floor with a pass
Hey,
recommendation.
Skog, you did a good job there, buddy,
roll call
lining
vote.
up your committee. All from
Representative Scott,
Yes.
Representative Ehart,
Yes.
Representative Erickson,
Yes.
Representative Garner,
No.
Representative Handy,
Yes.
Representative Hawkins,
Yes.
Representative Hill,
Yes.
Representative Hostetler,
Yes.
Representative Pohanka,
Yes.
Representative Schertz,
Yes.
Representative Gannon, Representative Carlson,
No.
Representative Rubel,
No.
Representative Skog.
Yes.
Okay, you notice that Scott changed her vote. So you want to be officially in line with the Idaho Republican, well, let's see, Alec and...
Motion carries 10-4.
Uh-huh.
I believe that concludes our business, and because we got through this today, we will not meet on Friday.